Good morning, sir. You're Corey Flemings.
Yes, ma'am.
And Mr. Flemings, and is it the same in each case, or was it an agreement for a dismissal in one? Or
It was intended to run concurrent of all the 8 years.
okay, and did you do 2 pleas?
All right, pause right there. This is already getting serious. The moment you hear multiple cases, you know this isn't just a bad day in court. This is someone's entire future hanging in the balance. And look at the setup. 2 cases, 1 deal, and already some confusion. That's dangerous, because in court, confusion is not your friend. It's where mistakes are made, and mistakes cost years. Now here's what makes this intense. The judge isn't just reading charges. She's about to break down sentencing ranges. And trust me, once those numbers come out, reality hits hard. We're talking about the difference between walking free in a few years or potentially losing decades of your life. So let me ask you this. If you were standing there, hearing all this for the first time, would you fully understand what's at stake? Or would you just nod and say, yes, ma'am, like most people do under pressure? Because that right there is where everything can go wrong.
Okay, they're both here? Okay, I'm sorry, I just saw one. Mr. Flemings, in cause number 24, DCCR 2144, you're charged with the second-degree felony offense of assault on a peace officer from September 11th of 2024. That indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, September 27th of 2023. And what that means is that if you go to trial and you're found guilty and that prior offense is true, the range of punishment would be between that of a first-degree felony, which is between 5 years and up to 99 years or life in prison. Do you understand?
Pause right here. This is where things get serious. The judge is breaking down sentencing ranges, and notice how fast it escalates from a regular felony straight into life-altering time. Question is, does the defendant really understand what's at stake?
Understand?
Yes, ma'am.
Sorry to interrupt.
Yes.
I believe the defendant's criminal.
And there it is. That one phrase changes everything. Habitual offender. If you don't know what that means, let me break it down real simple. This is the system saying, we've seen you before, and now the consequences go up. This isn't just stacking charges anymore. This is stacking history. And once the state proves prior felonies, the law doesn't just punish the current crime, it punishes the pattern. That's why you heard the jump from 5 years to potentially 25 years minimum. That's not a small increase. That's life-altering. And here's the scary part. Sometimes defendants don't fully grasp this moment. They hear numbers, but they don't feel the weight of them yet. Meanwhile, the judge is laying it all out crystal clear because legally she has to make sure he understands before anything moves forward. So think about this. If you were offered a deal before hearing this and then you hear 25 to life, does that change your decision? Because for Corey, this is the exact moment where the risk just became very, very real.
District lends itself to being a habitual offender, and I have every intention of filing the habitual offender notice.
Okay, and Mr. LeBlanc, did you go over that with him as well?
No, you and I talked about that outside.
Oh, as far as the
25 to 99. Yeah.
So, the state has information, he says, that you have more than one felony conviction from before. So if that's true, if you have at least 2 that are from different dates and you are found guilty, that changes this from a first degree up to a habitual offender status, which is a minimum of 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
And in cause number 24 DCCR 2145, you're charged with the state jail felony offense of injury to a child.
Boom. Did you catch that? Habitual offender status. That's the legal system saying you've been here before, too many times. Minimum 25 years. No shortcuts, no easy way out. Would you risk a trial knowing that?
Elderly or disabled individual from September 11th of 2024. That indictment alleges several prior state jail felony offenses. And when I say several, I mean 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 prior state jail felony offenses. It does not allege those prior regular felony offenses, but if you have, again, 2 regular felonies that are sequenced, not on the same day, in that case, it would make it a second-degree felony offense for punishment purposes, which has a punishment range between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
Judge,
And-
I'm sorry to interrupt again. I want to correct the record. I misspoke. Mr. LeBlanc and I talked about it being enhanced to a regular first degree.
Okay.
599. We
Okay.
didn't specifically talk about the 2599. I don't want to.
Y'all didn't, but you do have the prior, so it could be. Y'all just didn't discuss it.
Yes, ma'am.
Okay. So, but you understand now, I've admonished you, and you understand, and you know what your history.
This right here is one of the most important moments in the entire courtroom, and most people miss it. The judge is doing what's called an admonishment. That means she's officially putting everything on record so there's no confusion later. In simple terms, she's saying, I've warned you. You know the consequences. What happens next is your choice. And that matters because once a defendant says, yes, I understand, it becomes very hard to argue later that they didn't know what they were risking. The system protects itself by making sure you acknowledge the danger before stepping into it. But here's where it gets psychological. A lot of people in this situation are overwhelmed. They're stressed, maybe scared, maybe frustrated, and sometimes they just agree to everything without fully processing it. So I gotta ask you, do you think Corey truly understands what 25 years minimum actually feels like? Or is this one of those moments where reality hasn't fully hit yet?
Is if you have a prior felony, 2 prior felonies that aren't state jail, and you're found guilty, then the minimum punishment is 25 years. You understand?
Yes, ma'am.
And that's on the assault case of a peace officer. And the other range of punishment in the injury to a child would be 2 to 20. You understand?
Yes, ma'am.
Okay, and so I have here on the computer plea bargain rejections that you've signed with Mr. LeBlanc that shows that the district attorney's office has made an offer of 8 years in each of those cases to run concurrently, which means at the same time. You have every right to reject that and have your cases set for.
Now this is the turning point, an 8-year deal on the table, concurrent sentences, meaning both cases run together. It's actually a strategic lifeline. But here's the twist. Is pride about to cost him decades?
Whoa, that's the moment. He just rejected 8 years to take his chances at trial. Now let's really break this down. The deal was 8 years running at the same time. That's predictable. That's controlled risk. But trial, that's a gamble, and not a small one. We're talking about potentially jumping from 8 years to decades behind bars if things go wrong. And here's the truth about trials. They're unpredictable. You're putting your fate in the hands of a jury, evidence, witnesses, and how well your lawyer performs under pressure. One bad day, one strong witness, one mistake, and everything changes. But at the same time, people don't reject deals for no reason. Maybe he believes he can win. Maybe he thinks the evidence is weak. Or maybe he just doesn't want to accept guilt. So let me ask you, was this a bold move or a dangerous one? Because moments like this don't just decide cases, they decide lives.
Trial, I just want to make sure you understand what your possible consequences are if you go to trial, what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your cases set for trial?
Yes, ma'am.
All right, we'll get it set for trial. Mr. LeBlanc will begin preparation for trial. You can go back with the bailiff. All right, ma'am, your Casey Bean.
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Sure, Your Honor.
And there it is. He rejects the deal. This is the kind of decision that can define a life. High risk, high reward, or high regret. Do you think he just made the biggest mistake of his life?
Ms. Bean, in cause number 23, DCCR 2068, you're charged with theft of property in an amount more than $2,500 with previous convictions, which is a third-degree felony, from April 6th of 2023. The indictment alleges you were previously convicted of theft September 4th of 2014, December 22nd of 2015, December 6th of 2017, December 7th of 2018, and June 24th of 2019. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
And then in cause number 23, DCCR 2069, you're also charged with theft of property with previous convictions in an amount more than $2,500 from June 25th of 2023. And how do you plead to that charge?
Guilty.
That's also alleges all of those same prior offenses. And are all of those same prior offenses true?
Yes, ma'am.
And in this case, did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Bean is not competent?
No, Your Honor.
All right, ma'am. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 23, DCCR 2069, find sufficient evidence to find you guilty, and at this time find you guilty of theft with previous convictions in an amount above.
And just like that, 4 years. No drama, no shouting, just a calm, controlled decision that changes someone's life instantly. This is something a lot of people don't realize about courtrooms. It's not always loud or emotional. Sometimes the biggest consequences are delivered quietly, almost routinely. But don't let that calm tone fool you. This is heavy. Now, in Casey's situation, those prior theft convictions played a huge role. The system doesn't just look at what you did today, it looks at what you done before. And when there's a pattern, the punishment escalates. That's how the law works. Also notice, she accepted a deal. Unlike Corey, she chose certainty over risk, and because of that, she avoided something potentially worse. So here's the comparison moment. One defendant gambles, another takes the deal. Which one made the smarter move?
$2,500, sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that the law gives you the right to receive. In addition to that, I will give you credit for any from the date of.
Switching gears, but same courtroom reality. Notice how smooth and fast this guilty plea goes. No hesitation, no gamble. This is what accepting a deal looks like. Controlled damage instead of total collapse.
Indictments in each of these cases, which is from November 29th of 2023. So you will receive credit from November 29th of 2023. Y'all have marked that on here as 624 days. I'm going to assume that y'all did that math correctly. But it's for sure from the date of indictment on each case. Do you understand? And then in cause number 23, DCCR 206, which one did I just do?
6-8, was it?
You just did 9. I think you-
Well, I did the plea papers, but then which one did I make the finding
I'm
on?
not sure.
That I made the finding? Okay. In 23 DCCR, you good? Sorry. 2068, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of theft with prior convictions in an amount above $2,500. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Correction. You will also receive credit on that for any time that you've been in custody that the law gives you the right to receive, and also specifically from the date of indictment, which is November 29th of 2023. These two cases will run concurrently, which means together at the same time. I have handed you the trial court certification in each case that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right, good luck to you, ma'am. You can go back with the bailiff.
And a GPS. That's your bond. Yes, sir. Yes, ma'am, we'll just need to set it for our contested.
Are you going to plea on the motion? Have y'all talked about it?
Well, he has a new aggravated robbery.
There's a new aggravated robbery.
So it'll have to be printed up.
Okay. So we're just gonna enter pleas on the motion?
He'll interplead to not treat him requested hearing. Yes, ma'am.
Question. Mr. Kidd, raise your right hand the best you can, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can put your hand down. Will he waive the formal reading of the motion?
So waived.
Mr. Kidd, in cause number 21-38744, I have a first amended motion to revoke your unadjudicated probation. It shows that you were placed on probation November 16th of 2022 for the offense of robbery, a second-degree felony, and that was a 10-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 2 alleges that you failed to immediately report your arrest to your probation officer from March 24th of 2024. Is that true or not true? Count 3 alleges that you were in an establishment licensed to serve alcoholic beverages March 24th of 2024 in violation of your probation. Is that true or not true?
It's true, I was there, but it was in.
Hang on, I just need trues or not true. Count
3 should have been.
4, I'm sorry, I skipped 3. That was count 4. I'll enter a plea of truth for count 4. Count 3, count 3 alleges that you failed to provide proof of filing or attempting to file your taxes for the year 2023. Is that true or not true? Count 5 alleges that you were at a location other than your residence at approximately 1:20 a.m. March 24th of 2024. And is that true or not true? Count 6 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true? I'm sorry? Not true. Count 7 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? Count 8 alleges that as of April 16th, 2024, you were $400 behind in payments of restitution to the victim. Is that true or not true? Count 9 alleges that you were behind in your court-assessed fees in the amount of $761 as of April 16th of 2024. Is that true or not true? Count 10 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy. Is that true or not true? Count 11 alleges that you committed the new offense of aggravated robbery February 19th of 2025. Is that true or not true?
Not true.
Count 12 alleges that you failed to report to the Jefferson County Probation Department since April 16th of 2024. Is that true or not true?
Not true.
Count 13 alleges that as of March 3rd of 2025, you're $1,813 behind in your fees. Is that true or not true? All right, so did you enter your pleas of true to counts 4, 5, 8, 9, and 13 freely and voluntarily? Those are the counts that you pled true to. Nobody forced you to plead true to those, did they? All right, then I'm going to find counts 4, 5, 8, 9, and 13 true, find sufficient evidence.
Now, this is a different kind of power move from the judge, and it's subtle. She revokes probation, but delays sentencing. Why? Strategy. This gives both sides time. The defense can prepare, bring evidence, maybe even try to soften the outcome, and the court gets a clearer picture before deciding final punishment. It's not mercy, it's calculated patience. But don't get it twisted. This isn't a second chance. This is more like the calm before the storm. Because once that sentencing hearing comes, that's it. No more delays, no more chances to explain, just the final decision. And honestly, this is where pressure builds the most. Waiting, not knowing what your future holds. That mental weight sometimes is just as heavy as the sentence itself. So let me ask you, would you rather know your sentence immediately or live with that uncertainty hanging over you?
to find you guilty and revoke your probation. However, I'm going to reset your case for a sentencing hearing. Mr. Smith, if you will check into obviously that new case, we will set some time appropriate for you to bring witnesses and get any discovery that you can get to Mr. Kimler before that date.
Yes, sir.
Okay?
I'd say you're going to proceed on the administrative case also, and then put up through.
We'll make sure we have plenty of time for you.
Ordered an updated PSI.
Yes, and I'll get an updated pre-sentence
Those will
report.
all be addressed by should be addressed by the probation.
They should, and we'll make sure we have that probation officer here as well for those administrative hearing issues. And then whatever you need as far as time for the new offense, we'll give you plenty of time for that.
And in the event that he posts bond, he needs to report to the probation department to schedule for that pre-sentence report.
All right, you can go back with the bailiff.